Welcome. My name is Robert Sterne, and I am Editor-in-Chief of Patent Office Litigation, the first and definitive book on the new contested proceedings at the United States Patent and Trademark Office. It is June 2013, and almost 9 months has gone since the first new contested proceedings became operational at the United States Patent and Trademark Office. Over 300 inter-party reviews and covered business method proceedings have been petitioned at the new Patent Trial and Appeal Board. Many of these have been ordered for trial at the board. Since September of 2012, I have delivered 19 presentations around the U.S. on these new proceedings. I have taught the ins and outs of the new contested proceedings to over 3,000 patent professionals. This is more than anyone else has done to date. I mentioned this to provide the context for this short presentation on what I have titled Patent Zombies. At conferences, the new defense strategy against patent trolls involves use of these new contested proceedings. IPRs and CBM proceedings form the backbone of this new anti-troll strategy. Because the patent troll community, as it is derogatorily characterized, is unaware or asleep about this new and often deadly defense strategy, proponents of this new strategy have labeled these unaware patent owners as patent zombies. Patent zombies, I guess, suggests that the patent owners who are asserting their patents are already dead in terms of their patent enforcement strategy because of the new contested proceedings, but do not realize their demise yet, hence the catchy patent zombie label. I am an attorney of record in more than a dozen of these new contested proceedings, and my contested proceedings team at Sterne Kessler is involved in more of them than practically any other firm in the United States. I often represent the patent owner, some of which could be labeled patent trolls, using the broad brush of the defense bar. So I have a perspective of both the patent owner and the new accused infringer that I want to bring to this very topical and important patent zombie discussion. Now, there are 5 important points that the accused infringer needs to know when contemplating the use of the new contested proceedings to defend against a non-practicing entity. I use non-practicing entity because the courts may be swayed in certain critical respects by the fact that the patent owner is not practicing the patent technology. This NPE label is less broad and is less pejorative and broader than the patent troll moniker. First, many NPEs have not factored into their enforcement budget and strategy the defense of a contested proceeding. These patent owners are still operating under the old district court and USITC enforcement model that existed prior to September of 2012. The failure to assume that the contested proceeding is going to be brought against the patents they are asserting is a fundamental economic and strategy mistake. The probability is very high that an accused infringer will bring a contested proceeding as a defense, particularly if the patent is in the predictable arts. In fact, there is a very significant probability that at least one defendant will bring a contested proceeding as a defense in a multi-defendant enforcement program. Moreover, it is quite possible that more than one proceeding will be brought by several defendants, either alone or in groups, depending on the timing of these multiple proceedings. It is probable that the board will consolidate them into one proceeding. Now, it is very important to understand that the defense of these proceedings must be taken extremely seriously. If the patent owner fails in these contested proceedings in any way, their entire enforcement program could be thwarted, if not destroyed. And therefore, to not allocate the resources, the people and the money needed to defend the patent by the patent owner will be fatal under these new contested proceedings. While it is true that the new contested proceedings may be more favorable to the patent owner than the legacy inter-party re-examinations, nonetheless, the importance of experts and expert declarations and depositions and how the new contested proceedings are dealt with and how the defense needs to be brought at the very beginning of the proceedings all add up to the simple fact that the patent owner must take these proceedings very seriously, must assume that they will take place, and must provide the budget and the team in order to defend them. A failure to do this will turn the patent owner into a patent zombie. Now, my second point that the accused infringer must contemplate is the delay that the contested proceeding will introduce to the enforcement program. This delay could be anywhere from 2 to 4 years. How do I come up with this number? Well, first of all, the contested proceedings will involve a search of the prior art or an identification of the defenses that will be brought in the contested proceeding, depending on which one is used. Moreover, once the petition is filed, the rules at the Patent Trial and Appeal Board provide a 6-month period before the PTAB must decide whether to institute the trial. So that is 6 months that is in the equation. Once the trial is instituted by statute, the trial must run 12 months, 18 months in exceptional circumstance, but one must assume that 12 months will be the period. So hence 6 months plus 12 months plus the identification of the defenses. Once the board has issued a final written decision within the 12-month statutory period, or 18 months in exceptional circumstances, the case proceeds to an appeal to the Federal Circuit, which adds additional delay. So therefore, during this entire period, the patent owner will have to be dealing with this new contested proceeding. It will be distracted, it will have additional costs, and it will have additional reasons to settle with one or more of the parties that have brought the contested proceedings. For these reasons, many accused infringers are looking very favorably on the use of contested proceedings as a defense strategy to either force settlement or to win the entire situation. The third point that I want to bring to the attention of the accused infringer bar is the possibility that the court will grant a stay of the suit pending completion of the contested proceeding at the Patent Office. One of the reasons why courts did not provide stays in the inter-party re-examination situation that existed before the new AIA proceedings became operational was the very significant amount of time, usually 5 to 8 years, that the inter-party re-examinations took to be completed at the Patent Office and then at the Federal Circuit. One of the major goals of the new contested proceedings under the AIA is the statutory requirement that the trial be completed within 12 months. Courts have been told this by the PTO in meetings with judges and members of the International Trade Commission in Washington, D.C. These judges now know that the new contested proceedings are slated to be much more timely than the prior inter-party re-examinations. And for these reasons, among others, district court judges in particular, maybe not the ITC, but district court judges in particular may be inclined to stay one or more of their court cases pending completion of the contested proceeding involving the same patents that are in suit. And there is no absolute requirement that the judge stay the proceeding in the district court pending completion of the contested proceedings, but the judges have wide latitude, and my guess is that on appeal, the Federal Circuit will not second guess the staying of cases. The fourth point that I want to bring to the attention of the accused infringer bar is the probability of success that the petitioner, hence the accused infringer, will prevail in having some or all of the claims in the contested proceeding found to be unpatentable. So why is this the case? Well, simply put, anticipation and obviousness can be raised in the IPR proceeding, as well as other defenses in the CBM. The board at the Patent Office, the Patent Trial and Appeal Board, will be very adept in applying patent law to the issues at hand. They will be very familiar with the law of obviousness, for example. And as I have stated in other videos that you can find on the internet, particularly through YouTube, the probability that a patent claim in a predictable art will be found to be obvious is very high. So therefore, the patent owner is at much more significant risk of losing their patents in these contested proceedings than they would be involving the same art before a jury in a district court case or before an administrative law judge at the ITC. So therefore, the patent owner should be very concerned about the possibility of loss in one of these contested proceedings. My fifth and final point is the probability that the Federal Circuit, in the appeal of the contested proceeding, will confirm the finding of unpatentability of the board. There will be a dramatic increase in the number of appeals that will be brought from the Patent Office to the Federal Circuit under this new regime. It could jump from 150 appeals a year to easily 700 or 800 appeals a year. The Federal Circuit will be overwhelmed, frankly, by this new workload because they will not be able to add additional judges or, frankly, maybe even additional law clerks to deal with this increased amount, a dramatic increased amount of work that is coming their way. And they're aware of this. Moreover, they will provide significant administrative deference to the agency in their appeal process. For these reasons, I predict and others predict that it will be difficult to overcome a finding of unpatentability from the board on appeal at the Federal Circuit. And for this reason, the accused infringer bar should emphasize this when they are discussing bringing a contested proceeding or when they are negotiating with the patent owner. All of these factors should be put into the equation in deciding whether to bring a contested proceeding and how to use the contested proceeding to drive a favorable settlement or a favorable result in litigation in the United States today. Thank you very much.